I'm Cynthia Rowland, and this is episode 127 of EO Radio Show. This is a refresh of our episode 13, first dropped on August 29th, 2022, which covered record retention policies, document destruction schedules, and why they matter. Many nonprofits today have heightened concerns about legal actions, investigations by the IRS, or congressional committees, as well as lawsuits, and are proactively looking at their document management systems and policies. And regardless of those sorts of current concerns, many nonprofit leaders are or should be aware that the IRS Form 990, which is the information return for nonprofit organizations, specifically asks the filing organization if it has a document retention policy. While there is no penalty imposed by the Internal Revenue Code for not having a document retention policy, not only is it good form to be able to indicate yes on the Form 990, but also having a formal written retention policy is certainly a best practice. In the original episode from 2022, my former partner Aviva Gilbert joined me to provide real-world perspective about how a document retention policy plays out in real life when the nonprofit faces an investigation or is subject to a document request involving other outside parties. Her comments are as helpful today as they were in 2022. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. In 2002, Congress enacted legislation known as the Sarbanes-Oxley Act. Section 1102 or 1102 of Sarbanes-Oxley addresses document destruction. Under this law, it is a criminal offense to corruptly alter, destroy, mutilate, or conceal a record to prevent its use in any official federal proceeding, including a federal tax audit. While criminal document destruction is not top of mind for most charities and foundations, the real risk of improper destruction is the devastating impact it can have in the context of an investigation or legal dispute. Back in the early 2000s, when I first started helping organizations to create document retention policies and schedules for destruction of various categories of documents, the key driver was saving the cost of storing all that paper. Obviously, document destruction is a necessary process for any organization. In light of the substantial penalties for improper destruction on the one hand, and the costs of storing enormous quantities of electronic records on the other, it is important that charities and foundations have in place a monitored document retention and destruction policy. The policy should address not only the proper handling of paper documents, but also electronic documents and voicemail. The policy should also include systems for backing up and checking the reliability of the document retention system. Finally, the policy must include procedures for protecting documents that are in any way relevant to an official investigation that is underway or even suspected. Let's keep in mind the formal purpose of this document retention policy. The purpose is to retain records in the appropriate files for each matter for an appropriate period of time, to destroy records that are unlikely to ever be needed again, and to consistently apply the policy over time. A good document retention policy delegates executive responsibility to an officer who's familiar with the business records and systems so that they can and will periodically monitor compliance and step in as necessary to address any problems. The 6 key features of creating and implementing an effective policy are the following. Number 1, identify the permanently valuable records of the institution or those functions and activities for which documentation must be preserved in accordance with a records retention policy acknowledgement form. Number 2, specify through records retention schedules records to be preserved either for the term stated or in archives to be kept for the life of the organization. Those archived documents include things such as formation documents, minute books, insurance policies, and the like. The retention periods for other records that don't need to be kept for the life of the organization depend on the type of the record. You might check with an employment law specialist for the requirements in your state for employee records. In addition, tax records are generally advised to be kept for at least 7 years following the date of filing with the taxing authority. For organizations in California, I generally recommend most records be kept for 10 years. And that's because the limitations period for an investigation by the California Attorney General's office is 10 years. For charities not registered in California, a shorter retention period may make good sense. Number 3, arrange for the destruction of all documents upon the expiration of the required retention period and maintain a log of record destruction. Number 4, routinely audit compliance with the policy and the uniform application of the retention schedule by randomly reviewing the files in all departments to see that the retention schedules are followed. Number 5, make sure that employees are trained in procedures to be followed for the creation and implementation of records retention schedules. And number 6, halt the destruction timetable for a record or a series of records whenever a litigation hold is in effect. With that summary of the 6 key features of a records retention policy, I want to introduce Aviva Gilbert. She'll talk about some specifics from the investigating lawyer's perspective. Aviva has extensive experience appearing before and negotiating with agencies like the U.S. Department of Justice, the Securities and Exchange Commission, the Department of Health and Human Services, and the California Attorney General's Office. Her investigation experience involves high-profile tech, healthcare, biotech, and consumer goods companies, as well as financial services entities, educational institutions, and large public organizations, as well as nonprofits. Thanks for taking the time to talk with me today, Aviva.
Thanks, Cynthia. Very happy to be here.
As we dive into this, I've talked a little bit about the policies, which is kind of hopefully abstract and academic. Let's start with the first call you get. When I need to pull you into an investigation for a nonprofit, does it matter to document retention whether the investigation originates with a government entity or, say, an internal investigation in response to a whistleblower?
That's a really good question. The answer is no, it doesn't. The way in which it is different is that the stakes can be different, but they're high in both instances, whether it's a whistleblower, more of like an internal initiated issue, or a government inquiry. The stakes are high in both instances. And what that really means is that having a document retention policy of the type that you described, part of good corporate hygiene, it's something that every organization should have in place. You hope you never have to pull documents from your storage, but you might, and that can happen in response to a government inquiry or a whistleblower-generated investigation or litigation. That's another very common, probably the most common, actually, either government or a litigation situation that requires you to either produce or review documents that you've been holding. When I say the stakes are high, what I mean is if an investigation proceeds to some kind of enforcement action or a complaint ends up proceeding to litigation, is determined or it comes out that the organization did not have a reasonable retention policy, that can lead to something as serious as an adverse inference, meaning that you automatically lose on certain issues in court. So the stakes can be really high if you don't have a reasonable hold in place.
So that's a good point, Aviva. Sarbanes-Oxley applies technically just to criminal penalties for destruction of certain kinds of records. But what you're suggesting is you're not necessarily going to jail for document destruction, but it could be financially very painful.
Right, because sort of the criminal penalties could flow in some circumstances. But probably the more common issue is that you'll end up in a lawsuit. And if it comes out that somebody either, hopefully not intentionally, but let's just say intentionally did not preserve or destroy documents that were relevant and they had reason to know that can mean you automatically lose on certain instances, and that can be very expensive.
So that's the adverse inference that you're referring to?
That's right. And the sort of inside baseball term for when that evidence goes missing is spoliation.
The policy describes a litigation hold and the effort to make sure that this bad things don't happen. So I'm at a nonprofit. I find out there's a disgruntled person who's making noises like they might bring a legal action against the nonprofit. What's the first thing I do as the executive at the nonprofit that just found out about this? I haven't even hired a lawyer yet.
That's a really good question. And the answer to that is you implement a litigation hold. And usually you would hire a lawyer before that gets formalized. But a litigation hold is different than a document retention policy because a policy is an overarching umbrella framework that you have in place throughout the life of the organization. A litigation hold relates specifically to a threatened or actual investigation or lawsuit or demand, something that you know is coming, that you need to have the right document documents preserved and possibly available for production in that context. It's episodic, and it may cover only the people who were involved in the deal or who were involved in a particular dispute, something like that, or a particular interaction. So a litigation hold, it's broad enough to cover everything you might need, but it doesn't cover everything that's ever existed in the organization's history. Let me add one other thing, Cynthia, about litigation holds. So kind of functionally how that happens is there's two pieces. One is you will inform, probably a secretary or administrative or in-house counsel, somebody like that will inform the relevant people that there's going to be a litigation hold and put them on notice that they need to preserve their notes, anything handwritten, not to destroy anything. And then on the back end, you'll work with IT and whoever manages your document retention to make sure that the specific records that are covered by the hold are not subject to any normal automatic deletion. Because like you mentioned, you can delete things after 10 years generally, but there may be some instances where you don't want to do even that.
So that reminded me of my other question that I wanted to bring up, and that is the importance of not creating more records. Often I see a litigation hold that is addressed to the particular narrow group that might have relevant records and usually sets a point person and tries to contain creation of additional messages like, what? I can't believe so-and-so is going to do something like that after everything we've done for them. How important is it to get people to kind of take a breath and be thoughtful about what they put in writing going forward? There's probably a more articulate way that you describe it to clients.
Take a breath is exactly the right way to describe it. I think that's good advice, good counsel for any person working at any organization at any time. I think if you have possibly negative or challenging things to say about an employee or a potential whistleblower or a coworker, it's not the best advice or the best behavior to put that in writing. At the same time, I don't think we need to look at this through the lens of don't create additional records. Organizations need to be able to run themselves and do their business, and people need to be free to do their work without worrying about how much paper they're creating. But I do think your point that it's always important to be thoughtful in how you communicate is a critical one. And the thing I see the most is people treating, and applies to government investigations, criminal and civil and litigation and internal investigations. People treat text messages and WhatsApp and any kind of more casual than email messaging interaction as though it's not recorded, as though it's the same as speaking sort of voice to voice. And it's not. That's a document that's preserved, that has to be produced if a subpoena calls for it. So that's, I would say, the most challenging thing that I work with clients is, of course, nobody thinks that their text messages are ever going to end up in litigation or being produced, and they are.
Yeah, they are. And even the text messaging features that supposedly destroy the texts after a certain period, that are automatically set up so that they don't retain an extensive history. Anybody can screenshot it. I should say the recipient can screenshot the message. So
that's right. And I think I'm not an expert on the disappearing messages technology, but I also think you can appreciate that in some corporate entities, what looks like it's deleted on an individual employee's phone may actually be preserved in the company's server somewhere as well. I've seen that happen.
So turning back to what happens, what does this look like over the course of an investigation? Now our nonprofits reach the point in the investigation where the other side has asked for the records, and you use that legal term there, a subpoena has arrived. Talk a little bit about what's usually in a request for the records, who responds to it, and then more importantly, can I just print all of it and send them a bunch of boxes?
I wouldn't advise that for both environmental and practical reasons. That sounds challenging. I think we're in an age now where even if the relevant records are paper records, those are going to be scanned and transmitted electronically. There's just not going to be a lot of paper flying back and forth and responding to a subpoena. But as to your question about what is in a subpoena, it's going to be broad probably, because whoever's asking for it is going to want to sort of get as much as possible. And it's going to state the specific individuals possibly whose documents are requested, potential subject matter that is relevant that might be requested. What else? Time period, that's key. And then you'll also get, with almost every subpoena, a sort of administrative formatting language around how the records are to be produced. Oh, and it'll, of course, state text messages, communications, it'll specify the stores that you need to go to as well.
Many of us, myself included, generate hundreds of electronic documents every day. And suppose I do, in fact, keep them all, because I actually am somewhat of a hoarder. I've got a lot of stuff. Does everything get turned over? I want to back up a second to when the lawyer gets involved. Sometimes you don't have to, I'm going to digress a little bit for our nonprofit executives. Sometimes you don't need to go out and hire a new lawyer. Often the claim is covered by insurance. So the first thing you do is tell your insurance company. They may assign counsel to you. So now you've gotten the subpoena, you have a lawyer you can talk to or at least reach, and you know you have to provide something. How does that even happen? How does this huge trove of stuff that's stored here and there and on clouds and so on, how does one go about turning over everything? And then second question, I'm throwing a lot at you. Do I have to send all my emails? I mean, I have 5 for every lunch meeting and then my own medical appointments and my text to and from my kids.
That's a really good question. Well, hopefully your text to and from your kids won't be called for in the subpoena unless you were texting with them about the subject matter at issue. And then they might be. Let's hope not. So that's a really good question. So you will want to appoint somebody internally who's going to help run the show. And that person should either have a close relationship with your IT department or be able to create one quickly, because that's really the person who's going to kind of know where the bodies are buried, so to speak, when it comes to documents, not actual bodies. But let's hope. That's a different episode. But you'll need somebody internally who's going to kind of run the show. Then you'll want counsel to advise on a few things. First, on where to draw the lines based on what the subpoena is asking for. And second, to supervise or conduct themselves what's called a privilege review. And so I'll talk in a second about how you kind of get documents. But the answer to your question is no, you won't turn over everything. One of the things you'll do is make sure that emails that are privileged, for example, between a company representative or employee and counsel talking about legal advice or trying to get legal advice, that you do not produce, even if it is relevant to the dispute at issue. There's other privileges as well. That's the main one that we're thinking about, but there's spousal privilege. So if you were emailing about something with your spouse, that doesn't necessarily need to be produced. But once the documents and the materials are collected, they'll be loaded onto what's called a review platform. And then somebody will be looking at probably a subset of the documents to make sure that only what needs to go and what is not privileged goes to the other side. And that applies to the government or to private litigants. And then the other thing to note is, like you said, many people, most of us now produce huge amounts of material, most of which is not going to be relevant. And the way that that line is drawn and the way that that filtration happens is via search terms. So we get all the data. Usually we work with an IT professional or somebody who can help us. There's vendors that do this also, but if there's an in-house person, maybe you might get the entirety of a particular individual's email for a particular period of time, and that's going to be an enormous amount of data. But you apply search terms, and there's very sophisticated ways that that can happen. But those search terms are designed to pull out only what is relevant to the specific matter at issue. And often those search terms will be agreed upon by the parties, or I'll work with the government to make sure that they're okay with the search terms that I'm going to be using. And once everybody's on the same page about that, you'll apply those, and it really has the effect of narrowing the universe substantially.
I have to say that sounds kind of expensive. You're talking about a lot of experts in fields that are not, unless I'm a huge nonprofit institution, an educational institution or something. Does it get really expensive? Look like for the nonprofit that reaches this stage?
It's a good question. Yes. Unfortunately, the answer, I don't want to sort of beat around the bush. It's expensive. It's an expensive part of litigation. There's a couple of things that are important to remember that will help keep it under control. One is almost every law firm has an in-house sort of review platform, and you're not going to have to go to a separate vendor to generally do the document review and get a separate contract set up to load all the material. Hopefully, your counsel will be able to run that show internally. That's an important thing. And the other is, in certain circumstances, especially if cost is a significant hurdle, you can agree that, for example, every email to and from Cynthia, your lawyer, is not going to get looked at. That's going to just get pulled out because that's presumptively privileged. And so there's sort of shortcuts, or you could say that every email between these two people is going to be produced, and try to reduce some of the review portion by creating these automatic rules. Because what gets really expensive is not so much the data, that we traffic in such high sort of bandwidth scenarios now that It's not the amount of data that makes it expensive. It's if you have to put eyeballs on everything. That's what gets really expensive. We don't yet have AI that can do that effectively. I know that there's various startups that are working on it, but for now, it's the eyeballs on the emails that gets pricey.
So that reminds me of another situation that comes up with nonprofits from time to time that's super annoying, but not necessarily high stakes. And that is when a nonprofit gets drawn into somebody else's fight and their document retention for that. Do the same kind of penalties and issues apply if you're just providing information for someone else's dispute? How do we think about that?
Yeah, that's a really good question. Frankly, when you and I have worked together on a variety of situations where that's the case. So a subpoena is a court order. So you don't have the option of saying, go pound sand, because it is a court order that the parties obtain. But the presumptions are a little bit preferential of third parties and understanding that third parties really don't have skin in the game and it's not their fight. What that means is one thing you could do, we haven't talked about this, it's probably also another episode, but if the burden is extreme, the burden associated with responding is extreme, you can object. And then if the other side or the party wanting the documents pushes back, you can go to court to try to get a court order telling you don't have to do this production, because while a subpoena is a court order, the court isn't reviewing every subpoena. It's sort of like a form that has the power of the court, but they're not looking at it. So what you can do is say, hey, judge, I want you to look at this. This is an extreme burden for me. I don't have the resources to do this. I'm not even involved in this fight. Either quash it entirely or I propose this narrowed approach. So that can be a cost-effective sense if the burden is extreme, that you might just try to fight it, sort of go on offense if you have to. First, you'd say, no, I'm not going to do that. Then if you get some pushback and you try to negotiate and you can't get somewhere reasonable, you do have the option of going to court and demonstrating that burden. And for third parties, the bar is a lot lower.
Oh, that's good to know. I think in our matters, we haven't actually gotten to the point of having to go to court because the counsel for whoever's asking for it, they take a reasonable approach as well, right? I mean,
Right. They know that the bar is lower for third parties. They're just interested in getting documents. And so I would say more commonly what you and I have seen is we'll negotiate a more narrow, either time period or shorter list of people, something designed to try to get them what they want without burdening our client too severely. Like anything, a negotiated resolution is usually going to be the best one, even though it makes no one happy.
Right. That makes sense. Wrapping up a little bit and coming back to the main theme that I'm hoping is the takeaway is having a good policy in place. Any additional thoughts on best practices and maybe even some war story or something? Sometimes the worst possible outcomes are the best stories, but any further thoughts?
I had a client once who was just a meticulous note taker in the Moleskine notebooks and was an employee of an organization that actually was involved in an investigation and so didn't have the third party sort of lower bar. And we had to scan and then look at, I think it was 4 years of just meticulous handwritten notes in Moleskines. And thankfully, their handwriting was good. So it was sort of feasible to understand what's going on. But taking hard copy notes, I know that people don't do it that much anymore. It certainly is a bigger challenge in the document retention world. But just in terms of best practices, this is an ounce of prevention is a pound of cure situation. Much better to spend the money once upfront working with counsel just to make sure you have good hygiene and everything in place so that if you need it later, it's a lot cheaper and a lot easier to access the data.
This is a good way to kind of close out the thoughts. So in my retention schedules that I talked about at the very beginning, for a large organization or even for a small one, we might have different kinds of records that we keep personnel records for a little while. We keep insurance policies forever. Maybe we set up that our emails go away after however much time. How important is it to actually follow that kind of a schedule? And secondly, when I get the subpoena and I'm like, oh, my policy said I only had to keep it for 5 years, so I can go and get rid of those now? The ones that are past their retention period?
Well, you should have a policy that is sort of automatically deleting data after the retention period expires. You don't want to be in a scenario where you're on notice that you need something and then you go delete it. Bad behavior that, as you can put yourself in the judge's seat or on the bench, that's not going to look good. You don't want to do that. But you can delete things after the time period, of course, unless there's a litigation hold in place or have reason to know that that's coming imminently. But you really just want to set it up to happen automatically so you're reducing the brain power and man hours that are spent managing as you go.
Right. And that comes back to you keep business records for a reasonable period. And then when there's no longer a reasonable expectation that you'll need those records, then they should be destroyed. And this may be a whole other episode. What does it actually mean to destroy electronic records that are in the cloud? So maybe we'll save that for another day. But I think that's at least internally, an organization can say after this amount of time, we're disconnecting our records.
Yeah, they auto delete. Most of the cloud sort of storage providers have auto deletion. Usually it's on the months or years type of schedule. And you just want to run whatever time period you're proposing by your counsel to make sure that that's reasonable in your jurisdiction. But that aspect of the technology is pretty well established. And then I think on paper records, though, of course, they're not as common as they used to be. On a 10-year basis, you should be able to sort of go in and purge what you don't need anymore.
Well, that's great. Aviva, thank you so much for having this conversation with me. For listeners who'd like to hear more on the topic of best practices for preparing for investigations, check the show notes for a link to our full webinar in late 2021 on investigations, audits, subpoenas, oh my, which is available on our events page at the Farella, Braun & Martel website.
That was a fun one. Thanks, Cynthia. This has been a really enjoyable conversation.
This is great, Aviva. Thanks so much.
All right.
Well, that's it for today. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.